Gov, are you ready?
Yeah.
You ready? Okay, then without further ado, let's have an order. All the Prime Minister, you have the party to be the first
Here.
Thank you very, very much, Madam Speaker. This most august House, both sides, Amanda, for what's been an amazing weekend. So I haven't been this excited about running a case. I really believe in what we're going to talk about today. So let me give you a little bit of background. We're going to put you, Madam Speaker, members of this panel, as a single issue advocacy group of a constitutional right or a constitutional issue. So like you are something like, NARAL, or something like gay rights or civil rights, like something that believes in one single issue that you're really trying to get into the public eye, that you're trying to get into society, and you're trying to protect some group of individuals' rights or some right that you believe is fundamental. Because of limited resources, you only have the ability to either legislate through the Congress or to litigate through the courts. What we want to ask a side opposition is, which do you choose, litigate or legislate? Go ahead, take as much time as you want. Love this case. Look at it. We'll litigate. Score! Okay. So I want to show you why they're drastically wrong and why you lose all forms of legitimacy when you decide to litigate, and why legislate is the correct way.
No, wait, dude, we said, we're going to legislate, right? Yeah,
I
legislate.
thought you said litigate.
We did, but we meant legislate, I'm sorry.
We're going to show you why you don't get any legitimacy and no chance of winning when you decide to legislate. Alright, so we're going to show you why litigation is the correct way to do this. The first thing we want to talk about is efficiency and effectiveness. What you need to realize is that litigation is contained in the courts, while legislation is contained in the mass public. What this means is that even if you believe in the idea of engendering political discourse, even if you believe in all these great ideas about the political democracy, what you have to understand is you don't really give expletive here, anything about whether or not you get this thing passed in the public eye. What you care about is that you have a substantial decision that some group in society is going to have some fundamental rights actually protected, and we think that's really important. But additionally, in litigation, you only have to convince a panel of expert judges. In the legislation, you have to convince hundreds of legislators and thousands upon thousands of people to actually believe in your movement and to contribute to your movement so that you can actually get the ball rolling. We think that's extremely hard. But additionally, successful litigation is better for organizations like yours. Why? Well, when you litigate, we see that the groups that litigate are often the ones that get the public interest. They're the ones that get the newspaper. ACLU wins historic court landmark battle. Like NARAL wins rights for women. What you don't see, however, is that happening in the legislature. Lieberman passes decision. Kerry passes decision. But you don't see the fact that the ACLU was instrumental in getting that into the Congress in the first place. What this means is that your group, which as much as it's trying to fight for certain rights, you also want to make sure that you can protect those rights in the future. And when nobody knows that you're the one that actually did it in the first place, nobody's going to contribute to you in the future, and nobody's actually going to care in the future because they didn't know that you actually had any landmark battles, that you actually had any success in the past. But additionally, on our side of the house, you have funding for later cases because people care, and because there's precedent on our side of the house. On that side of the house, when a new administration comes in, or when another party takes control, whatever goals that you succeeded in passing get thrown out the window. You can have them just reverse your decision. But look at the courts. Historically, they're very, very kind of edgy about making sure that they keep precedent. They don't want to go ahead and reverse decisions. The fact that Lawrence was such an important landmark battle was because Lawrence was one of the first reversals of Supreme Court precedent in so long. Usually they just try to stick to precedent, and that's why we have more and more of a conservative courts. We realize that it's really important to make sure that the courts are the ones that actually establish precedent, and that you're not going to have some party coming in 4 years and overturning the work that you spent so many dollars and so many hours of effort and trying to get passed in the first place. The second thing you want to talk about, however, is the likelihood of success. Because you're a single-issue advocacy group. You believe in something that's probably not popular. You believe in something that is probably not supported by everyone in society. That's why it's not in law yet. That's why it's not codified. What this means is that there's a significant amount of people who are against you, which means that, one, you are going to mobilize them in fighting against you in the Congress, and that they're going to be talking to their senators, and they're going to be talking to their congressmen and trying to fight you. But additionally, now you have to get all of these people who you don't even know if they exist or believe in your cause to try to fight for you and try to fund your efforts, which we don't think you're going to be able to do. It's extremely hard to mobilize American voters who aren't in the political elite because we are so apathetic, because we believe that our voices don't matter. In the courts, you don't have to consider consider the American Joe. You don't have to consider these practical concerns about funding or resources or about getting people to believe in your cause. All you have to do is to make sure that you can convince 5 out of 9 judges that you're right and that these rights ought to be fundamental.
Here.
Further, we believe that now in the courts, you change something now. You don't have to wait 4 years until it's put into place. You don't have to lobby for like 10 years. You don't have to do these things. When you have a court case, it's decided then. There's less of a lag time and more people are helped. But you disagree.
But Neil, if you're talking about a case that goes all the way to the Supreme Court, don't those cases typically take years and years and years because of the tremendous appeals process?
Sure, there are lots of decisions that take a while to get to the courts, but the overwhelmingly, like the average of the amount of time that it takes to get these issues decided in the legislature is much longer because of the mobilization time. Because you can't mobilize hundreds of thousands of voters in a month, or in a year, or in 2 years. It takes a lot of time to get people behind some type of issue. The third thing we want to talk about finally is the idea of justice. Because the outcome of the litigation is likely to be better, because in the Congress you have compromise. You don't believe in a compromise on rights. You don't believe that your organization should play the political game. You don't believe that rights ought to be tied to political values. You believe that these are the only things that matter, that getting all of these rights matter, and that's the only win that you're likely to take or that you're willing to take. We think that in the Congress you are much more likely to give and take. You're much more likely to compromise with the opposing party. You're much more likely to have the legislation changed in conference committee or something like this. While in the courts, there is no question of compromise, and at that point, you have much more of a substantive outcome. But additionally, you shouldn't be compromising on issues of things like torture, or privacy, or equality, or things that we believe are fundamental rights, because rights shouldn't have that on the table. But the point of the Constitution and the point of fundamental rights as we believe them is that's what they are. We can compromise some things. We can compromise the amount of money we give to people on welfare. We can compromise the amount of money that we decide to give to public education. But we cannot, Madam Speaker, members of this panel, decide to compromise on the protection of fundamental rights. For all of those reasons, we propose.
I'd like to thank you, Madam Speaker, everyone on this panel, everyone in this most august house, Neil for taping this, and of course Dave for giving a fantastic demo in just a few moments' time. And before I get into the specific points that Neil brought up, I've got a couple of reasons of my own why you should actually go to the legislature, not to the courts, and litigate your fundamental rights. The first thing I'm going to talk about is test cases. Understand that it's very difficult to get a test case that is particular to your issue, right? Understand that people who have been trying to challenge affirmative action have been waiting decades for the proper test case to come along so that they can challenge this in the courts. Because the problem is that every single case isn't just about one issue. A law can be just about affirmative action. A law can be just about race relations, or it can be just about women's rights, or something like that. But a test case, when you're talking about a court case, actually involves all the particulars of that case. And because of that, if you want to set a clear precedent, if you want to be sure that this right is absolutely protected, and not protected just in cases which are very similar to the case that you were talking about, you have to get the proper case. And that can become very difficult, it can become very time-consuming. We would say that if you want to get legislative action, it's better to say exactly what you're going to do rather than being down to particulars of the court. Sure.
But Robert, the example you give us of affirmative action, the emphasis on that has been much more in the courts than such things like Grotter v. Bollinger and Bakke than in the federal government through the legislature, right?
Well, I would say that's not necessarily true. Consider the state of California, which bans affirmative action in all of its state universities. What I would say is if you want to look at like getting rid of affirmative action necessarily, affirmative action was put in essentially by the legislature. It was put in at the same time as civil rights. It was put in at the same time as President Johnson. How has it been removed? It's been removed again by the legislature. People have been trying to challenge affirmative action in the courts. They've been very unsuccessful in challenging it from the courts because they've been having a hard time showing the test case, having a hard time proving that a person like only got in because of affirmative action. I would say is because it's very difficult and time-consuming to do so, it's better that you should go for these for the legislature. The second thing I want to talk about is who exactly are you going to be lobbying in the courts? Because understand that lobbying the legislature is encouraged. It's allowed. In fact, there are people, like, they live on one street in Washington, they all lobby legislatures. Lobbying a judge is a crime, right? Like, I mean, come on, guys. How exactly are you going to get people to do this? What they're saying is it's hard to mobilize large numbers of people. What I would say is I think it's actually very difficult to necessarily like lobby judges. It's very hard to get people on your side, and it's not totally clear how you would go about challenging this in the courts, right? Like, let's say the court right now believes that like affirmative action is fantastic, like you should have it at the University of Michigan. How exactly would you go about changing this if you're a lobby group? Would you try to like lobby the president to have him put new people on the court? Or would you go to the individual court members and say, look, you know, I'll give you a couple $1,000s for your re-election campaign that you don't have? Right? Like, it's not totally clear exactly how you would go about this. With the legislature, at least there's a tried and true method. Maybe it's not the most effective method, but at least it's a path that you can go down. It's not totally clear exactly what they would do. The next thing I would say is that, again, it's hard to find too, and you can chew down to the specifics. With this sort of legislation, you can actually write this with particulars into the law. And I say this is very important on issues where it is actually when it is actually bound to certain specific details. Consider, example, abortion rights, right? Maybe you want abortion only in the first trimester, but not after that. I think it's very difficult to find that necessarily in the Constitution. Now, Roe versus Wade did that, I'll admit that right now. But the fact is that a lot of people don't like Roe versus Wade, even people who support abortion, because they feel that the court was essentially making up law, that this is something better suited to the legislators. Certain issues of public policy, when it is acceptable to discriminate on the basis of race, when it is acceptable to take away someone's property. These are things that need to be fine-tuned, things that need to be specific. I don't think that you want to necessarily leave this all up to a judge who writes his opinion and to the vagaries of people interpreting that opinion in the future. I think you want the legislature to clearly delineate these things. If, as he says, rights are very important, you don't want to leave it to people interpreting it. You don't want to leave it to people interpreting it. You want to leave it to people who write it down in actual detail. The next thing I would say is that arbitrating in the courts is vulnerable to stare decisis. Or actually to the lack of stare decisis. New judges can come in and they can essentially overturn your verdict. And what I would say is unless you want to continue to try to protect the court by constantly lobbying judges, I don't think it's necessarily a good idea to try to get this done through the court. Understand that all it takes to reverse a decision is one judge says, I don't want this anymore, and then an appellate judge agrees with him. Unless you want this thing to be constantly challenged, unless you want this thing to be something that's going to be litigated for essentially the foreseeable future, I think you should go to the courts because I think you should go, to the legislature, because in the legislature it's very clear. Sure.
Okay, but don't the courts have a propensity to not care, or to make sure that they always care about precedent and try not to overturn it?
Okay, courts do care about precedent, but they don't always care about precedent. I understand that, for example, in the affirmative action case at the University of Michigan, they ruled that the undergraduate admission process, that was absolutely unacceptable. So, at least in that circumstance, they overruled precedent, so to speak. But also what I would say is that they may overrule part of precedent, right? You may have a decision that sort of overrules your decision, but doesn't totally overrule it because it's a different case. And because these are different cases, I would say that common law precedents tend to be a whole lot more nebulous and a whole lot less easy to enforce than, say, litigious rights which are delineated within the Constitution or within the legislature. So the next thing I would say, and I think one of the most important benefits here is that you can start small. Because understand that if you really feel this right is important, if you really feel this is something that people should take notice of and that people should be protected, then you can go to the state level in the state legislatures. Understand, this is how a lot of rights, particularly women's voting rights, actually came to the forefront. A small and dedicated group of individuals went to local state legislatures in places which were particularly liberal and particularly so to individual rights. And then they said, look, this is really important. They raised a whole lot of commotion there, and they got a law passed in that state. When people saw that state, then they got a whole lot more support for other states. You can start small. You don't have to go to the federal Supreme Court, where you'll be fighting people with tremendous amounts of money against you. You can start at local state courts where people local state legislatures where people necessarily like you, where people you can actually get support from. This is actually important. Also, what I say is you can get a partial victory here, right? With them and rights, it's just all or nothing, right? The precedent is either there in the court or it's not. At least you can get some kind of compromise in the legislature. Maybe you can get partial protection of rights. Maybe you can get possibly baby steps in this direction. That doesn't sound fantastic for a person who advocates an issue. What I would say is it's better for women to have some rights than not to have any rights at all. That's how, for example, the women's rights movement came forward. People getting small rights in small increments. I think that's the best way in order to get rights in America. With that said, let's go to the points that they bring up. The first thing they talk about is that it's hard to convince people. You have to rally thousands and thousands of people. Firstly, understand that lobbyists don't rally thousands and thousands of people. They go directly to the representatives. It's certainly possible to lobby Congress. Even if you don't think it's possible to lobby the National Congress, you can certainly lobby a state Congress in order to get this done. I don't think it's totally absurd to assume that you could do that. But also what I would say is how are you going to convince a judge? They haven't given you any process by which you can do this in the courts other than suing. And if the judges don't agree with you, what exactly are you going to do except sit there and not like it? The next thing they talk about is you get a whole lot of free press, organizations that challenge things in the court, that makes the news. Okay, that's fine. I would also say that controversial new laws also make the news. The Patriot Act, for example, which overruled a lot of civil rights, that's been in the news for a very long time. I don't think they can just claim on their side of the house that you get so much more exposure from a court decision than you do from, say, passing a law, even if it is on the state level or the national level. The next thing they say is nobody's going to know that you did it. Well, because I don't think that there's any way that you can do it, right? Because there isn't really a clear way to force a judge to rule in one way or another. So if you isn't a clear way to do that, then no, you really can't do it. That's why people don't know that you did it. The next thing they say is look, precedent, there's someone can just come into office and overturn this law later. Yes, that may be the case. That's a risk you take in democracy. But I'd say it's a lot easier for one judge to say overturn a decision than it is for one person to say overturn a law. You need the entire legislature to overturn a law. All you need is one degenerate judge to at least temporarily suspend a person's rights. The next thing they say is it's hard to mobilize voters. Yeah, it might be hard to mobilize voters. It's also hard to mobilize judges, but also what I'd say is you can lobby the representatives directly. You don't necessarily have to mobilize all of the voters. But also what I would say is, like, look, guys, if you really want to get people to recognize a right that hasn't been recognized before, you really do have to mobilize the entire country. Because regardless of whether you go through the legislature, and regardless of whether you go through the courts, people simply aren't going to enforce this law, and people simply aren't going to act in recognition of it if they don't believe in it. So I'd say is you have to mobilize people in either side of the House, so I don't think this flows to any side or the other. And the last thing I talk about is justice. They say compromise in the legal system is bad. I would say compromise at least gives you partial victories, something to work from, something to use in order to go for future rights. It's very difficult to get everything at once, and for all these reasons, we're proud of each other.
All right, I'd like to thank the leader of opposition for his remarks and call upon the member of government, men and to be the second speaker around which is direction of government.
Here, here.
Thank you very much, Madam Speaker, members of this most august House, the panel, side opposition for I thought was a great opposition to our case, Neil, for debating with me this weekend. It's been a great time. I've had a whole lot of fun, and just everyone for being here. So I just want to jump into what the leader of opposition started with, because essentially they've chosen the side to legislate, and they think that this is going to add more legitimacy to their cause and actually help their cause. But I think something that they actually miss very large on their side of the House is when you choose to legislate and start small, like they're proposing on their side of the House, you build up more opposition because you have more time to build up that opposition, right? If you're not just going through the courts, and say you're trying to do this on a state-by-state basis, I don't know, try and get civil unions if you start in Vermont. The moment this passes in the Vermont legislature, all of a sudden everyone mobilizes against it, and it makes it harder for you to pass it in the next state, because everyone in that state, everyone in the state who won it, now goes to mobilize in other states. We think that's very problematic. You don't get that when you take it to the courts. It doesn't become like how many angry people who are just like against your cause because they don't believe in rights and they don't believe in your cause can convince their state legislatures. It actually becomes a matter of justice, where 7 people say, or like 5 out of 9 people say, whether or not they think that it's constitutional and you ought to have this right. If you start doing it step by step, and you do it just in the state legislature, you're going to mobilize all those people against you during the civil rights movement. You're going to mobilize all the bigots who think and who are racist and things like that against you, and it's going to make it much more harder, much more difficult to pass it in the next state that you go to. We think that's very problematic, and I think something they essentially miss on their side of the House. They talk about test cases. They're like, it's really difficult to get test cases. So even if you're putting all your resources into this one cause, it's going to be a while before a test case can get up there. Look, we recognize that it might take some time before it gets to the Supreme Court, but recognize there's also a large time lag on their side of the House. Also see that it oftentimes takes courts making decisions before legislatures will ever move on a politically hot issue, right? Because if there are a lot of people for and a lot of people against this issue, the legislatures aren't going to want to move unless there's someone else to legitimize their decision. If the courts come out in favor and then say, well, Brown v. Board of Education, we think separate but equal is not something that involves segregations in schools, then the legislature says, well, look, we have some precedent to act on, now we're going to go and pass the civil rights movement. Recognize that you make the courts legitimate, especially when issues are politically hot and there are people for and against it. So yes, we admit on our side of the House that coming up with a test case and someone to bring to the Supreme Court, that might take time. But in the time that it takes, it will take even more additional time if you're going to go with that side of the House, especially if you're going state by state. If it dies in the first state, or if it passes in one state, it makes it much more difficult for it to become something that everybody has to follow. On our side of the House, everyone has to take it as well. On their side of the House, gay people can only go to Vermont and sometimes Hawaii. What is the next thing they talk about? I don't remember what Hawaii said. They're weird. So the next thing they talk about is lobbying. They're like, well, you can lobby these politicians. You can't lobby judges. I think this is a really stupid point, right? How do you want to legitimize your cause? Be like, well, we were uber political, and we managed to get the Democrats on our side, and we managed to split the population, and we managed to convince some people that it would be better for them electorally if they were to pass this sort of law, rather than say, look, this is something that's just. This is something that applies to everybody, beyond Democrats, beyond Republicans. It applies to everyone in the entire United States. You don't need to be able to lobby judges. That's the good thing about the judicial system. That's what makes the decision you get on our side of the House more legitimate than the decision you get on their side of the House. You don't agree.
So what exactly are you proposing that you do though? If a judge doesn't agree with you, how exactly do you get these people on your side? You can obviously lobby representatives to pass a law, but what exactly is your movement going to be doing in order to try to move in the courts?
Our movement, basically what the movement does is says, look, we have this issue. We want to mobilize people behind this issue. We're going to take this court case and we're going to say, look, this is very important. We're going to have a lot of people rallying behind our issue at the courts, marching in favor of our issue, saying we believe that this is right. But what it comes down to is a lot more based on the facts on our side of the house. We don't want some kind of a compromise. We think that it's something that's fundamental, a right that everybody should have, not something that ought to be compromised in the courts. We recognize that, yes, you can lobby people, but you're also not getting the legitimacy, something we talk about on case, for your group individually, but rather just for these specific politicians that end up passing it. And then it doesn't help your cause at all, and all the people who did hard work when it comes up, and when it's overturned later on in the legislature, something else that we talk about, like, all these people, all their work would have gone to waste. Yes, you can't lobby, but you could still lobby like people behind you when you have a court case. You still had people marching in favor of Roe v. Wade, trying to protect women's rights, right? It wasn't like everyone was like, oh, well, there's a court case going on, we're just going to sit at home and watch it. No, people talked about it. It created discourse, and in the end, it was a legitimate decision because it wasn't an over-political decision. It was a decision based on rights that people should have. The next thing that they talk about is that really it's like hard to find in the Constitution, like the court can't really make up law. I think this is absolutely ridiculous, right? What they're proposing on their side of the house is that the law is based, like, essentially like the law is controlled by politics. And they're saying, well, the courts can't make this kind of law. That's not true. The court sets the precedent. The court says, look, there's this fundamental right that people should have. Law, essentially, when they say that something is a fundamental right. Right? Because this happens all the time. Like, new judges come onto the court, and they're like, I really want to seem legitimate. I really want to seem like I can, like, interpret the Constitution. I'm just going to go down, and I'm going to find some cases. I'm just going to totally overturn them, because I've got to prove myself. It's, like, complete bullshit. Like, all precedent will tell you that judges tend to, like, respect the precedent within the courts. They don't come in, and the first thing that they do is overturn some sort of law. No, thank you. I think that this is really important. As Neil pointed out, one of the biggest things about the sodomy laws that were just overturned, but it was just that. The Supreme Court was overturning one of their past decisions. Every time another case comes up that's going to overturn a past case, it's a really big deal because this doesn't happen all the time. On the other hand, when you get a new, like, controlled Congress, all of a sudden Congress is controlled by the Republicans, all of a sudden we have a different president in office, and their party doesn't agree, your issue's going to go out the window. If you're fighting for, women's rights and you want to have abortion that was done by the legislature, when the Republicans come in, what do? They just change things, and we don't think that you want your issue to just fall back there.
Sure. So you're telling me that overturning precedent is really, 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 really hard. Isn't that what you're advocating on your side of the house?
Right? We're advocating setting a precedent, right? We're saying we think that you ought to have a specific right. We're saying this is something that you don't have, something that hasn't been specifically, like, debated about. They talk about the affirmative action case. Recognize that what was brought before the courts, while they may think was overturning precedent, was actually a new case. It was a new issue in regards to affirmative action, the way the undergraduate situation was being handled. It wasn't an overturning of some past case that had occurred, but rather something new that was being brought to the courts. We're not overturning precedent on our side of the house, we're setting precedent. We're saying, we think this is a fundamental right. We think that women ought to have the right to decide what they want to do with their bodies. It wasn't like Roe v. Wade was overturning this. Roe v. Wade was deciding that women ought to have this specific right. And we think that's essentially. The next thing they talk about is just starting small. I think I've already addressed this and how this is actually going to hurt your movement more than it's going to help it. So I'm just going to move case side, because they don't actually spend any time on case. The first thing that we talk about is how it's more efficient and more effective. If you want to make change, if you want to keep your group of people mobilized and interested, you need to have sort of this change happen and happen quickly. We say it happens more quickly on our side of the house. On their side of the house, you could spend years lobbying. Clearly this is not going to be a very popular issue, and it's going to be very difficult for legislatures to decide and to be able to say, well, look, we're going to vote for this really hot potato kind of issue. It's going to take a lot of time. At least on our side of the house, you get a decision quicker, and you get a more permanent decision. We think it's more effective and more efficient, and they don't adequately address that on their side of the house, other than to say you can start with state congresses. Recognize that the state congress doesn't look to the other state congress for their precedent on what laws to pass, whereas courts do have to look at the precedent that's going to be set if you go with what's on our side of the house. We talk about the fact of precedent. They don't respond to this at all, except to say judges are going to overturn. Remember, doesn't happen all the time, happens very rarely, and if they're going to claim that it does happen on their side of the house, recognize it happens 10,000 times more often on what they're giving you on their side. We talk about the likelihood of success. We're like, it's probably not a popular issue. It's probably not going to be very successful if you put it into, the legislature if it's not popular. But if you actually do believe that it's a fundamental right and something that you should have, the probabilities of success within the courts with 9 people who are not controlled by these political parties to make this kind of decision and who are much more objective, you probably have a greater likelihood of success if you actually really believe in your cause. On their side of the house, they're going to get a compromise, and that's important. We talk about the fact of justice, and here they just reiterate everything they said before and don't actually make any kind of new argument. And we think this is very problematic, because what you want on our side of the House is justice. What you want for your issue is justice. And you're not going to get it on that side of the House if you have to compromise. If this is a really tenuous issue, if it's something that really is very controversial, the legislatures are going to try and soften the blow with their voters, especially because not all the voters in their state are of their party. They're going to want to sort of compromise and say, well, maybe can we throw in this about partial birth abortion, or maybe about the 5th week, or maybe about something like that, or it's going to sort of undermine rights that women have, or even in the civil rights movement, things such as that. We think it's very problematic that they're going to be able to compromise your issue just because of their political ties within the state. We think if you want justice, if you want things done effectively and efficiently, you vote for side vote.
Yeah.
All right, legislation member of government.
Thank you, Madam Speaker, for calling on me. Thank you, members of the panel, members of this most august House, for being here to listen to this round. Side government for an absolutely fantastic case. Like, this really is. It's wonderful. Everyone should have pounded for that as well. Thank you, Rob, for being here to debate with me. Gave a great speech earlier. He's going to give you another great speech later on. I want to start with an observation, which I guess you may as well label as an independent point, because everyone does anyway. What I want to say is that recognize the way in which the building process works on both sides of the House. On their side of the House, you bring a test case in front of a judge somewhere. It's probably in a state court somewhere. It's challenging a law, or perhaps it's a federal law. Either way, you start at the bottom, right? At that level, let's say you win. All right, you move up, and you move up, and you move up, and eventually you hit the Supreme Court, which is ultimately where you need to go in order to have any ruling that means anything at all. Because recognize, if you don't make it all the way to the Supreme Court, if you stop anywhere below and a judge disagrees with you, all of the work you've done goes to moot. Everything that you've done, everything you've invested in for lawyers and for making arguments is now gone. Because all of your building process on their side of the House doesn't build to anything. It steps in a ladder. But once you fall off the ladder, you're back on the ground again. What happens on our side of the House, though? If you convince a state Congress somewhere to pass a law in favor of this, you got supporters somewhere in a state. You've got representatives in another state who represent people who have congressmen as well. As you build up, either through the state level or if you start at the national level, lobbying congressmen as well, you recognize that you're getting voters on your side. Every person you convince, every legislator you get on your side, helps you later on. When we say start small, we don't just mean convince the people on the local level to do it. We're saying, like, pass the law one piece at a time. Because every time you pass a piece, and I'll talk about their building of opposition arguments later, I'll take you later, Nate. Okay. I don't want to make you stand.
Oh, okay.
I want to finish up. Look, like, every time you convince someone, and every time you pass a part of this law, you build upon yourself. You may generate more opposition, but recognize that the part where you lose, at the part where you have opposition on their side of the House, where there's a judge who disagrees with you, you lose everything that you built up completely. At least on our side of the House, if you have a partial failure, if one of your laws doesn't get passed, you still have your supporters and your resources haven't been tossed down the drain. Let's talk about this. Do you have something to say, Neil? Let's go.
No, don't worry about it.
With that said, let's talk about what Rob says. Rob first says, look, test cases are finicky little creatures, right? You might not get the test case you want and spend all of your money pushing it all the way to the Supreme Court, and then the ruling you get doesn't prove the right that you wanted. They don't address this analysis. The response that we get is, look, you know, one way or another, it's going to take time on both sides of the House, and you know, you have compromise on your side, so maybe you don't get what you want. But the fact of the matter is, at least we have control over our compromise on our side of the House. We decide what it means for these legislators to sit down. We tell them how we would like this law to be formed, and maybe the compromise that happens is only on a piece rather than the whole. We can have more control on our side of the House, sure.
How much impact do you think a single-issue advocacy group is going to have on members of the Senate in a conference committee?
Just as much impact as the single-issue advocacy group is going to have, given the amount of resources that they have, right? If they have a lot of resources, they can obviously do a lot on either side of the House. Hire a lot of lawyers, right? Research the topic very thoroughly. If they have a lot of resources on our side of the House, they can clearly lobby a lot of congressmen, right? One way or another, you can do something. It doesn't magically change just because we switch sides. Either way, that doesn't address the analysis. What I was saying before was, if we have a test case that doesn't prove your point, even if you pass it at the Supreme Court, you're screwed just because of technicalities. In any case, moving on, the next thing that they say is, that we talk about is the idea of who do you lobby. Obviously, one of the problems here is the fact that when you lobby a legislature, it's clear what you're doing. On our side, on their side of the House, all they can do is hire lawyers to research topics and hope they can come up with the best argument. But as Rob correctly points out, and Amanda doesn't really respond to, is if they just don't buy your argument, right? Like Roe v. Wade was kind of weird, right? You had to have a special judge to buy the Roe v. Wade logic. They had to actually want this issue to be passed in order for it to get through. Like, if it was the Roe v. Wade logic, but in another dress for another issue, and they just didn't agree with it, no matter how hard you try, you're done there, right? You can't get any further. But at least with us, you can convince them simply by virtue of the fact that you have supporters to do something. If it's popular, you can get it passed, rather than you have to make some guy agree with you. So the next thing that we talk about is the idea of the fact that the particulars of legislation are going to be easier to hammer out than the particulars of a test case. This is related. But firstly, what we would like to say, but additionally, the only response that we get here is the idea that, look, like, the only thing she picks on is the idea that new judges can change their mind. While we may say that the particulars can be different on both sides, oh, but if a judge can come and change their mind, Amanda just makes fun of this, that's just ridiculous. Understand that we're not talking about overturning the whole law necessarily. A lot of the time what happens is a judge comes along later and says, this ruling is mostly good, most of the things are agreed, but we'll partially overrule this part, right? The undergraduate system of affirmative action in University of Michigan is not okay. We'll overrule that. The details are what matter. And more importantly, when it's a broad decision that you have to cover a lot of things, the interpretation becomes very nebulous in the future. In the future, you can't lobby like the Congress again, or the people who are enforcing the law in order to decide how it's done. Once you have a decision on your hands, it's just up to the future judges to decide how it's enforced. It's up to the people to just arbitrarily interpret it. We think this is problematic because you don't have any control over it at that point either. Last thing we talk about is the idea of how you can start small. In addition to what I said before, that you building on yourself is actually productive and you don't lose all your resources that you've invested into this once you encounter a setback, we also say that you recognize that you can have partial successes that you can't have that have effect on the other side of the house. When you pass a law in a local level, it is in effect in that area. You have granted some people rights that they didn't have before, that you care about. On their side of the house, if you won one court battle, it means one man, one person, or one group is now benefited by that particular court decision. I think that what you have to have then is everyone, in order for something to actually happen, you need to actually push it all the way to the top for it to be universally applicable. Just winning at the local level doesn't allow you to do anything for the people in general. It only allows you to do something if you win your battle in totality. Let's go case side. The first thing that they talk about is the idea of how the courts are just, they say that, look, a lot of the time these are unpopular topics and you have to convince a lot of people in order to do this. We say that, look, at least you can start small so you don't have to convince everyone at once. And the only real response to this is that it's still just faster if you go through the courts. I really don't buy that, and I don't think we've gotten analysis as to why it is faster to litigate than it is to convince people. Like, you can pass a law really fast if everyone agrees, right? Like, let's say we pick an issue that for some reason there aren't rights about right now. There's a degenerate case in here where you go, look, there's no right for this particular thing, and everyone agrees there should be a right for it. Then you go to Congress, and Congress goes, yeah, obviously we agree with you. There should be a law protecting this right. The bill gets passed really fast. Likewise, on their side of the house, there could be, likewise that it can take a really long time, it can also take a long time on their side of the house, in that if you have to convince everyone every step of the way and construct all different test cases to make sure you cover all of the different parts of whatever it is that you're talking about, it could take decades in order to actually cover the objectives that you want. Well, the next thing that we talk about is the idea of how debate in Congress, bringing issues to the forefront and getting popularity is better for our side of the house because of the fact that we can work incrementally. They say that, look, you're just going to build opposition to yourself. And also, at least you have objective judges making decisions on their side. I think that, firstly, objective judges aren't useful to you if their brand of objectivity doesn't agree with what you're arguing for. Like we said before, it's hard to convince someone that you're right. It's very easy to convince someone that it's in their interest to pass a law. I think this is bad for you if what you ultimately want to do is achieve your purposes. Secondly, we also say that, look, like debating Congress, all of these things generate discussion. We don't know whether it's going to be good or bad. It may polarize people. People may be apathetic. I don't think this flows either way. I think it's pretty clear, though, that either way, if you're having people supporting something, it's better for it to be in the forefront for us, because that helps us discuss the issue and eventually come to some sort of resolution, a partial protection of rights, rather than on their side of the house where you have nothing at all. The second thing they talk about is the likelihood of success. They say, look, you need to mobilize a lot of voters no matter what. You have a problem. As we say again, look, you can incrementally go about this. You can have it passed in localities. You can also lobby for parts of these things that you want to be protected as you go along. The only response that we really get is that, look, like they say that no matter what, you're going to piss people off in this process. As I said before, I don't see why that's necessarily bad for us. At least it brings it into the forefront. It allows us to make more action of that. The last thing they talk about is justice. They say, look, compromise is just bad. I don't think that they're immune to compromise either on their side of the house. Recognize that judges have partial decisions all the time. They strike down parts of laws. the decision that they make about the test case may not be applicable to everyone you want to protect. In a lot of cases, it just doesn't help you to push it, or in a lot of cases, if you fail anywhere along the line, it doesn't help anyone at all, because then your decisions are completely moot. Recognize that you have to go all the way to the Supreme Court in order to cover everyone for anything. And for all of these reasons, we're very proud of you.
All right, I'd like to thank the member of opposition and call once again upon the leader of opposition, first one.
I'd like to thank you, Madam Speaker, everyone on the panel, everyone in this most august House, of course, Dave, for a fantastic MO, just as I promised, and to good friends here on site government for a very interesting case. Now, before I get into my points of crystallization, I have just a little bit of an overview here, because I want to be totally clear on what we're talking about. Because understand, this is obviously an issue on which people don't agree. Like, I think it's pretty obvious that, like, this is, if you actually have an issue advocacy group, like, this is clearly something that, like, not everybody agrees on. Like, there's no, like, no murder advocacy group. So what I would say is that as your advocacy group, you're going to have to convince some people in order to get this law passed on either side of the House, right? Like, you're going to have to convince some people. This isn't going to be something that's just going to go through the court, like, in one really quick decision. So what I would say is, at the point at which you recognize that you are going to have to convince some people, and in fact, you're going to have to convince probably a great many people, which side of the House gives you a better mechanism in order to go about doing that. The first thing I want to talk about here is what the hell are you doing specifically on either side of the House? Because on our side of the House, there's a very clear path to follow, right? Like, you can lobby legislators. You can lobby legislators on the national level, you can lobby them at the state level. You can start in states where, like, this issue is strong, right? Like, you can poll for it, figure out where it's actually strong, where people agree with this sort of thing. Start there and build up precedent. On their side of the House, what exactly do you do? Like, it's not totally clear. The only instrumental mechanism that Amanda gives you in her speech is mobilizing the populace and having marches on Washington. I would submit to you, Madam Speaker, that, like, the legislators who have to, like, respond to those voters who are marching on Washington are probably more likely to respond to a march on Washington than those Supreme Court justices who are elected for life. They don't give you any instrumental mechanism on their side of the House other than putting these cases in the court. What I would say is, if it were just a matter of, like, suing, if it were just a matter of putting this case in the court, then it wouldn't be an industry advocacy issue. Like, you wouldn't have to actually put this case forward because it already would have happened, right? If it were so easy and obvious that all you had to do was sue once in order to get this right passed, then it already would have happened. You wouldn't need this advocacy group. If you have to convince people, then I would say is that the best way to convince people is to do it slowly, to build up support, just to clearly have a path to do this. The second thing I want to talk about here is how do people get rights within the United States? Well, how have they in the past? If you look at the civil rights movement, if you look at the women's rights movement, they do so gradually, with little steps. Understand, Madam Speaker, that you're going to have to convince the vast majority of the populace on either side of the House. And people don't change fundamental views overnight. It would be fantastic if I could eliminate racism tomorrow with one Supreme Court decision. It would be fantastic if I could eliminate sexism tomorrow with one Supreme Court decision. But it actually takes quite a while. Consider how the death penalty has occurred in the United States, how the evolution of this issue has happened. First, a couple states pass a moratorium. Then some more states pass a moratorium. Then there are some there's some court issues. But what I would say is that, like, in 1950, like, no one probably would have challenged the death penalty. But today, it's a tight case on APDA to get rid of it. What I would say is that the tremendous popular support that you can get from mobilizing these people, from going on the state level, from starting small but building up, is actually something you should do. They claim that our process is slow. We say their process is just as slow, and you can't just, like, sneak in rights in the way that they're saying. Like, you can't just, like, catch people blind and, like, get rights into the courts. People simply aren't going to recognize that. But the last thing I want to talk about is what makes for the best protection, because I think that's what you really have to look for on, like, either side of the House here. What gets your issue there, and what makes sure that your issue is going to be recognized. When it's a law, it's clear, and in fact, it can be extremely clear. Gays can be married in Vermont. Like, there's no ambiguity about this. There's no question about, like, whether this precedent applies, right? Gays can definitely be married in Vermont. That's not total consent. That's not total, like, victory in terms of gay rights, but it's something, and it's something that can't simply be challenged. When it's a precedent, it's constantly challenged. Consider the affirmative action case that they bring up, right? Affirmative action was supposed to be decided in the courts, like, several decades ago, but people are still challenging it constantly because it's not clear, like, to what exactly that particular precedent applies. When it's a law, it's absolutely clear. When it's a law, you know that your rights are protected, but when it's simply a court ruling, it's vulnerable to the vagaries of the court and to random decisions by various judges. For all these reasons, we're proud of those.
Thanks, we have opposition called 5 minutes to do the final speech now.
I'm not going to tell you that either side in today's round gets all of the advantages. I'm not going to tell you that there's not a risk involved on either side of the House. I'm not going to tell you that every single thing that we tell you or that they tell you is going to fall on one side. What I am going to tell you is that the most effective way of getting your issue passed, the most effective way of getting on the political agenda, the most effective and efficient way of making sure that the fundamental rights that you believe in are actually protected is by going through the courts. And the reasoning is this. When you go through the courts, you have a legitimate decision that's based in legal theory and that's not based in politics. It's not based in, making sure that you convince enough Democrats that you're right and making sure that you polarize enough Republicans or that you didn't polarize enough Republicans. These aren't the things that you care about. These are the types of things that you want tied to your issue. The big thing that we get, the basis of all opposition philosophy, is you might lose. And we get this in the MO of, well, if you lose, you can't do anything. You just fall off the political ladder. Madam Speaker, I want to ask you a simple question. If you lose in Congress, if your vote gets to the congressional floor and they vote against you, how long do you think it's going to take for you to get back on the political agenda? If you lose once, you're not getting back up there, and they can't advocate on that side of the House that you can do it incrementally. Because Amanda gives you a stunning piece of analysis in her member of government speech. She tells you when you start small, you spur opposition. When you start small in Vermont and get gay unions there, you're going to have all hell of the conservatives going against you in every state you try to get this on. You give the opposition only more time to go against you, and then you only hurt your issue, and you only hurt your organization, and you only hurt your legitimacy. So there are three things I want to talk about. Oh, wait, no. There's one more thing I want to talk about before my crystallization, and it was this LOR overview, because I just want to mock this for a few seconds. So the big argument that we give you is the reason why you should go on our side of the House is because you don't have to mobilize people. And Glenn gets up and he's like, actually, you probably didn't know this, but you have to mobilize people on both sides. Just believe me. I swear to God, I'm right. No, he's wrong. You don't have to mobilize people on our side of the House. That's why our side of the House works. Because if you have an opposition-based issue, if you have an issue that a lot of people don't believe should be a right, if you have an issue that a lot of people don't believe that gays should have the right to marry, or that women should have the right to choose, or that blacks should be able to get an adequate education, if you have issues like that, you're only going to get opposition, and you're only going to mobilize the opposition when you go to the election. The three things I want to talk about are why democracy sucks, how your organization is affected, and how your issue works. So let's talk about democracy sucking. So people are apathetic, but you know who's not apathetic? People who really hate the people you're trying to work for. You know who's not apathetic? People who really hate people like me, or like Amanda, or like people who have a darker skin tone than I do. These people who live in states that end in Mississippi or Alabama. These are the people. These are the people who are going to be working against you. The crazy conservative coalition is not going to be like, so there are all these gay guys who want to get the right to marry. Let's not deal with it, even though we hope that they all die in hell. Let's not really care about it. Let's not expend huge amounts of resources trying to oppose them. No, obviously they're going to oppose you at every turn. And when they say start small on that side, the only thing that's going to happen is you're only going to incent more opposition. You're only going to have more opposition to your cause. These two believe that you're working in a power vacuum. They believe that for some reason, it's only you working against a neutral audience, and that all you have to do is convince them. Madam Speaker, members of this panel, let's put this issue at rest. You are not working in a vacuum. You are not working against neutral people. You are voting against people who don't believe in your cause and will fight against you. In the courts, you do not have that issue. In the courts, you do not have an opposition. You only have an impartial set of jurors who are there to decide whether or not your issue warrants protection. Judges are not politically viable, unlike the legislature. In the legislature, you know what happens? Laws are repealed. And they try to do the same thing that they did with the mobilization point. They try to say that repealing works on both sides. Again, this is a ridiculous point. If you really believe that laws are repealed more in the courts than they are, precedent is repealed more in the courts than laws are repealed in the Congress, you're just wrong. That's not the way that it works. The courts, the only way that courts can actually maintain legitimacy in the first place is by maintaining their precedent. And when they don't do that, they're not going to be able to have any legitimacy, which is why they respect precedent. And it's for those reasons, then, that you're not going to have the ability for all of your hard work to be overturned. Look, on either side of this house, you might lose. But on their side, you have the ability to win and then to have all of your resources taken away. On our side of the house, once you win, and it's codified in law and rights are protected. On that side of the house, it's only repealed and your work is only temporary. The second thing I want to talk about is your organization. Because on our side of the house, you get the publicity. You get the fact that it's the ACLU wins court battle. ACLU does this. On their side of the house, you have bipartisan conference committee compromise, work to ensure that some modicum of compromise of rights are essentially protected. Like, that's not what you want. You want the right to be fundamentally protected. You don't want compromise on this. They tell you, they don't give you any response to this, so we have to believe it's true. As an issue advocacy group, you don't believe that the fundamental right that you're trying to protect ought to be compromised. At that point, because it shouldn't be compromised, you shouldn't let it go through conference committee, you shouldn't let it be in the whims of the polity, you don't believe this is what you should do. You believe that you should go through the courts so they can actually construct a fundamental protection of the things that you hold dear. But additionally, you're going to be able to mobilize opposition not only against your issue, but against your organization as well, when you turn out to be the people who are trying to incite opposition in every single state legislature in our country. The MO tells us, well, you know, we have dialectic now, and now we can discuss it in society. I don't care if you discuss it in society. I care that my rights are protected and that I get the right to marry, or that she gets the right to an abortion. I don't care that people in society are actually talking about this in the first place. The final thing I want to talk about is very quickly your issue. The member of the opposition says there's a partial overturning, but it's much harder to do on our side of the House, and it's much easier on their side of the House when every 4 years, when the administration of the Congress changes, something's going to get overturned. Look, controversial issues don't get dealt with in Congress. Immigration did not get dealt with in Congress. It got dealt with the courts. The reason is because of the opposition, it didn't get done in Congress, because of the fact that there's so many people against it. Madam Speaker, members of this panel, it comes down to this. If you really believe that your right ought to be fundamental, that it ought to be protected, and that it ought to be permanent, you can't go with their side of the House. Brown v. Board of Education, Roe v. Wade, Lawrence v. Texas, Abington School District, Engel v. Patel, these are all court cases that went ahead, above and beyond the overview and the legitimacy of the Congress. They're not going to respect you. You're only going to get opposition, and on that side of the House, you lose. For those reasons, we propose.
I want to have your children.